It's with great pleasure that I introduce our last speaker for this session, Associate Professor AnnabelAhuririDriscoll. I think I met Annabel almost within my first week or two of moving to Ōtautahi 23 years ago, and it's been an absolute amazing privilege of mine to watch her complete her master's, her PhD, and undertake an amazing academic career, but also get more involved politically at the commissioning level. And I think she's going to talk about a little bit about that today. Annabel is at Te Whare Wānanga o Waitaha, so at the University of Canterbury. See, we're so inclusive here. We're collaborative. That's a Mātauranga Māori way of working. And she has done a lot of extensive work in Māori advancement in health and social justice. And some of you might be really familiar with her work around Māori adoption, which has had a lot of airtime recently, and I think is making a huge impact on the way we think about that take. So, ko mai te pakipaki kia, Annabel.
I must start by apologising for departing slightly from the brief today. I'm going to speak to two kaupapa that I've been involved in, but not only as a researcher and not only in relation to research. I'll be drawing in my lived experience as an adopted person and an activist/advocate. From my point of view, closed adoption and abuse in state and faith-based settings present us with some interesting questions about utility and what justice means in practice. And so I'm going to be drawing on my work in relation to the Royal Commission of Inquiry into Abuse of Care and in co-chair. So in 2022, I submitted evidence to the Royal Commission on the harms of closed adoption for Māori. And that included a critical utility analysis using Heather Michel's framework and Margaret Mutu's 2010 reading of the treaty articles. And it was very clear in doing that closed adoption legislation and practice breached guarantees and associated principles set out in each of the utility articles. So where Article 1 grants the Queen all the kāwanatanga of rangatira lands, which Mutu reads as control of her subjects living in New Zealand, the Adoption Act 1955 exceeds the bounds of this more limited kāwanatanga, extending to all adoption orders made on the application of any person, Māori or not, in respect of any child, Māori or not. So, although at this point in time, in the 1950s, the Māori Land Court retained jurisdiction for Māori adoptions, and that was where at least one parent and the child were categorised as Māori, they were subject to the same specifications and procedures. And so these included that no applications could be heard or determined in open court. Every adoption order would confer the surname of the adopting parent on the adopted child, and the adopted child was deemed as if born to the adopting parents. And this is the legal fiction at the heart of the adoption order that's so popular. So Māori were addressed as a ground responsibility in the Act. Oh, wee. My touch was a little bit too light. Oh, aroha mai. Okay, so in both of those acts, a Māori was deemed to be a person belonging to the Aboriginal race of New Zealand and half caste or more in terms of blood quantum. So this was a racial categorisation contrary to whakapapa. Māori who didn't meet the quantum qualification were recategorised and processed as European.
And when I saw that in writing, and some of my PhD research saw the tables in which Māori were converted to European, one of those profound moments. Deeming the adopted child as if born to their adoptive parents and no longer the child of their natural or existing parents contravenes notions of whakapapa as inalienable. And so this and the closed secretive nature of adoption arrangements and practice contravene the maintenance of relationships and the openness typical in whāngai. If adopted by non-kin, an adopted child was thereafter without the knowledge of whakapapa, birth parents and whānau that we know is critical for Māori identity and belonging. And so in Article 2, the Queen of England recognises the paramount and ultimate power and authority of rangatira over their lands, their villages, and all their treasured possessions, their taonga. And so the application of this article has been really well argued in claims regarding the Adoption Act 1955 and 1962 that have been lodged to the tribunal. Where children constitute a taonga, the rangatiratanga of Māori over their care has been successively undermined over many decades through the prohibition of whāngai as well as in the course of adoption. So whāngai was prohibited first in the Native Lands Act 1909, and that was simply confirmed in Section 19 of the Adoption Act, which declared adoption, according to Māori custom, not operative. The 1962 amendment removed what was the last remnants of a practice resembling whāngai through the Māori Land Court. And so this breaches protection of Māori custom assured in what we know as Article 4. Tikanga Māori is also disregarded more broadly through the refusal to acknowledge the responsibilities and rights of whānau hapu and iwi with respect to their children, with that authority placed exclusively in courts and state agencies. And so as Māori became increasingly urbanised in the 50s and 60s, they came under the watchful, disapproving eye of the state. Relative deprivation and poverty, coupled with distrust in Māori whānau and distasteful Māori ways of living, were utilised to justify the removal of children. And so adoption was one of the mechanisms by which children were removed, with some whānau coerced into relinquishing their children. So adoption then, through its removal of Māori children from whānau, impacted on the guarantee of Article 2 to tino rangatiratanga over kāinga, as has been discussed within Y2915, the Oranga Tamariki Urgent Inquiry. And in that report, the tribunal states, this is nothing less than a guarantee of the right to continue to organise and live as Māori. And fundamental to that is the right to care for and raise the next generation. And Article 3 promised that the Queen would care for all the Māori people of New Zealand and allow them all the same customs as the people of England. Equality was pursued in two ways in the closed adoption legislation. In the 1955 Act, the legal provision that disallowed Māori from adopting non-Māori children was overridden. And then in the 1962 Act, equality was then taken to mean that all adoptions, including Māori, would follow the same process in the Magistrates' Court. But as I've mentioned, that entailed the removal of what Māori considered to be an option that better served their needs in the Māori Land Court. We can't overlook the fact that adopted children didn't enjoy equality in terms of their birth relationships and the losses and harms incurred producing fair and unjust inequalities in health, social, cultural and intergenerational outcomes. That insistence on a blanket adoption mechanism applied to all is a breach of contemporary understandings of Article 3 as a guarantee of equity, entailing different mechanisms to achieve equitable outcomes, including options that give Māori the right to choose their social and cultural path. So what might te tiriti justice look like with respect to closed adoption? And this is a selection of, I guess, what's my wish list. You know, at the top there, the ultimate goals of an ideal child welfare system must be addressing and mitigating the determinants that lead to the removal of children from their kin in the first place and supporting optimal whānau functioning. The restoration of tino rangatiratanga over kāinga means strong, connected whānau looking after their own tamariki and thriving as Māori. Adoption reform should include the substitution of plenary with simple adoption, in which the adopted child's recognised in law as having both birth and adopted parents. And, you know, it's stunning to think that there was always that mechanism. It wasn't just that, you know, we ought to follow whāngai, but actually there is a Western practice in terms of simple adoption that was an option that was not followed within our jurisdiction. So, as I mentioned, this would deal with the problematic legal fiction, and it would re-envision adoption as an enduring agreement wherein birth and adoptive whānau are forever in relation through their shared care for the tamaiti. We'd also like to see a negotiated post-adoption cultural engagement plan, laying out provisions for ensuring a tamaiti's whakapapa connections are maintained through active and ongoing engagement, not just knowing about it, including registration with appropriate Māori or iwi entities. So this is sounding somewhat reminiscent of, you know, 7AA. Any decision-making relating to the tamaiti needs to, you know, drawing from Hirini Moko Mead's principles to uphold a tamaiti as a taonga, you know, our decision-making should consider explicitly that child's social place, their heritage, their culture and language, their Māori, mana and tapu. And that might require the involvement of skilled tikanga Māori advocates. Of course, these rights should be underpinned by an explicit Te Tiriti o Waitangi clause and ensuring consistency with both UNCROC, the United Nations Convention for the Rights of the Child, and the United Nations Declaration on the Rights of Indigenous Peoples. Our current adoption law is in breach of both of those, the Convention and the Declaration. Also, part of reinstituting rangatiratanga and providing these options must involve the repeal of Section 19 of the Adoption Act so that whāngai can be able to be practiced legitimately by whānau. It's not currently the case. But any consideration of whāngai needs to happen separately to adoption law reform and with Māori leadership. That's really important so that whāngai isn't conflated with legal adoption and so that Māori are able to determine how whāngai is defined and practiced. So, unfortunately, adoption law is no longer on the policy reform agenda. But because adopted people are included in the scope of the Royal Commission, there is the opportunity to address some of these issues through redress for abuse and care. And so when we were considering Te Tiriti o Waitangi with respect to redress for survivors in our work last year, a key part of that revolved around survivors' distinct experiences of colonisation and coloniality. Like other Māori, we were slotted into a racialised hierarchy, and we inherited the structural positioning of our parents, including the impacts of colonisation upon them and their forebears. But we were removed from our whānau, hapu, iwi and Māori communities, and so we experienced being Māori and colonised in utter isolation. And so through assimilation, as you know, via adoption, or marginalisation through state and faith-based care, we were disconnected from Te Ao Māori in a profound way, in between or on the margins of Māori society and or mainstream society. Some survivors asked the question, where were my people when I was being abused and neglected? And for many, if there has been a pathway back, it has been really fraught. So there are some concerns that a te tiriti lens, linked as it is to hapu and iwi, may divert attention away from survivors and their experiences and needs. So it's imperative that survivors are prioritised in redress. And so we recognised that te tiriti justice would need to be thought about differently. You know, first question, who is the treaty partner here? And where does rangatiratanga sit? Can a collective of survivors or a survivor-led redress entity constitute a treaty partner and exercise tino rangatiratanga? After some discussion with te tiriti legal experts, we dealt with this quandary by referring instead to the mana motuhake that survivors possess and the importance of a redress system upholding that. The second consideration that arose was that of tangata tiriti survivors and how te tiriti guarantees apply to them and the ways that they have been similarly affected. Under Article 1, tangata tiriti experienced abusive rather than honourable kāwanatanga, and they were also significantly, profoundly impacted in terms of determining their futures. And then under Article 3, neither Māori nor Tauiwi survivors were able to enjoy the rights and privileges accorded to other citizens. And so sitting outside of, but alongside te tiriti rights, are those rights enshrined in the Universal Declaration of Human Rights that ought to have been ensured for all survivors. These include the rights to freedom and safety from harm, to not suffer torture or slavery, to equal recognition and protection under the law, and to an adequate standard of living and education. Just not the case for so many survivors. In addition, the impacts of tūkino have significantly affected survivors' life prospects and the guarantees of equal opportunities and freedom from discrimination under the Human Rights Act 1993. And as I've alluded to, the treatment and experience of survivors have also contravened a raft of rights guaranteed in the United Nations Convention on the Rights of the Child and UNDRIP. So after consultation, we clarified that in recognising the situation and needs of tangata tiriti survivors, we were in no way conferring, transferring or applying te tiriti rights that have been guaranteed to tangata whenua. But a comforting and important assurance for us was that where te tiriti o Waitangi forms part of the foundation for the redress system, its benefits in terms of good governance and equity would also be enjoyed by tangata tiriti survivors. So as survivors, we are all in this together. We have to be. And may te tiriti keep us close together, not wide apart. Nō reira, tēnā koutou, tēnā koutou, tēnā tātou katoa.